Ladies and gentlemen, welcome to a special edition of Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and I'm thrilled to have you join us today for what promises to be an enlightening discussion on all things H1B. I'm also excited to introduce my esteemed co host and immigration expert himself, Ranjit Nagapri. Welcome, Ranjit, to the show.
Hi, everyone. It's nice to be here, and yeah, Rajni, you can go ahead.
Thank you so much, Ranjit. And today we have an incredible lineup of guests. Joining us are two distinguished attorneys, Prashanthi Reddy and Prashant Dubey, who are experts in immigration law, as well as the esteemed USCIS litigation attorney, Jonathan Wasden, and the insightful former US Visa Counselor Officer, Yvette Bansal. It's going to be an enlightening discussion. So, buckle up. Let's kick things off by introducing a fantastic guest. See, I'm as excited as a child. So, Prashanthi, Prashant, Jonathan, and Yvette. Welcome to the show, everyone.
Thank you.
Thank you, Rajni.
Well, everyone, I would like to tell you that please know that this session is being streamed live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any questions to the attorneys, wherever you're watching it from, please comment with your questions. We'll be glad to answer them. All right. So now, without any further ado, I would like to go ahead with my very first question, which is for all of you. So, Prashanthi, if you are okay, I would like to start with you and ask my very first question, and then I would like to go to the other attorneys.
Sure.
Okay, so it's related to the lottery predictions. So, what are your predictions for the H1B visa fiscal year 2025 lottery?
It's hard to predict, but I think the best way to predict is to look at the previous year's numbers and then kind of make a guesstimate of what to expect this year, and also keeping in mind the duplicate registrations that were filed last year. So, just to give you a perspective, the registrations filed in 2022 were about 308,613. 2023 was 483,000, almost 484,000. And then there was a whooping 780,000, almost 884 in 2024. And we know that last year was a total fiasco because of the multiple registrations.
Right.
Out of the 780,000 registrations filed, there were 408 multiple registrations. So almost half of those registrations were multiple registrations. And the year before, out of the 483, 165,000 were multiple registrations. So if you look at it, the registrations, the single registrations number hasn't really changed that much. So it's been in between 200 and 300,000. Last year was 350. The year before was 309. So I'm predicting based on that the numbers will be around, say, about 300 to 350 registrations this year. So let's see. Time will tell, but that's my prediction. Keeping in mind that there won't be as many multiple registrations this year. There might still be multiple registrations because beneficiaries might still want to file with more than one employer, just to make sure that they have the choice of employer and choice of job that they can take up once the registration gets picked. So they might file for more than one, but the incentive for filing multiple registrations, as you know, has been taken away this year because of the beneficiary-centric registrations. But yeah, so I think keeping in mind that the number of multiple registrations might be reduced, it might be around between 300 and 400,000 registrations this year.
Okay. I mean, still sounds like a lot, but then okay, let's go in this order: Prashanthi, John, Prashant, and then Yvette, because as we can see on the screen. So now, John, I would like to know from you: do you agree? Do you have the same predictions as Prashanthi?
So I think numbers will be closer to historical norms. So, on average, we were seeing before the current lottery system around 280 to 300,000 petitions filed. I think it'll be closer to that, just because there's no multiple registrations, or there can't be multiple registrations, but they're only counting the employee. And I think also the economy is probably going to make an impact on the number of registrations that people file, just because they're pretty hesitant about where the economy is going right now.
Okay. But then, John, what are predictions on fraud this year?
On fraud, there won't.
Yeah.
I don't think there'll be any lottery fraud, just because the issue of multiple registrations is gone. So, but fraud in general has become USCIS's top priority. That's why you see the processing times going so long, is because they assume fraud in every petition. And so they're investigating every petition from that angle. It just takes a long time. So they're very keyed up for making fraud findings, and something to be aware of.
Okay.
Let me ask a question, John. Can you hear me?
Yeah.
Yeah. So what do you think about, people or the companies who were in blacklisted, or, who misused the system last year? Are they going to be banned this time, or, are is USCIS going to focus more on them, or how does it work? What do you think about it?
So technically, USCIS doesn't have any legal authority to blacklist companies. And if they were to blacklist companies, they would have to publish that in what's called a system of record notification. And they haven't done so. That said, I know for a fact that they blacklisted companies. So they're in pretty clear violation of the law. And companies that are in that boat, if your employees are going to the consulate or going to the port of entry and being turned around saying, your company is a fraud, you need to start doing some Freedom of Information Act requests and suing for information and trying to clear your name.
Okay, thank you for the answer, John. And Prashant, now I would like to come to you. Before the show started, while we were chatting, you said it is hectic, this time of the year, right? And it's good hectic. So how much are you predicting?
Yeah. So I'm going to double up on what John and Prashanthi said, right? I think the number of registrations that we're going to see is probably going to hover around that 300 to 350,000 range. There are some external factors like the economy, interest rates, just overall health of businesses that may swing that number a little bit lower. I think what'll be really interesting to see is the number of selections this year, right? Because the lottery process has a bit of a funnel effect, right? It's not as if USCIS, selects exactly 85,000 registrations, right? They tend to select a little bit more than that. So when they started the system, they selected about 120,000, and then 131,000, and then 127,000 in 2023. And that number increased in 2024 as well, right? And so that's when we began to see the first lottery, second lottery, third lottery in one of the years, right? So I do anticipate that, again, we're going to see a number of selections that is going to be in the 100,000 range. And we will potentially also see a second lottery, right? So there are individuals that sometimes lose a lot of hope when their name doesn't come out of the lottery at the end of March. And they might, feel like, oh, okay, now, I don't have the advantage of the duplicate filings and things like that. But just keep in mind, I do think that multiple lottery selections are on the horizon this year, just given historical numbers and how those lottery selections have played out.
Okay, all right. Great. So Yvette, I would like to now come to you and ask you the same question. How much are you predicting?
It's all just speculation, I guess, based on historic demand. The number of students on OPT is pretty high. The U.S. economy, I guess you could call that neither here nor there. And historic trends, I think I'm going to go with 450,000 and go a little bit higher in my prediction, but I think everyone's prediction is pretty good. I just wanted to be a little bit different and look at the F1 numbers a little bit more, and also some H4s and Ls that may have a desire to go for the H1Bs, but it could be a little bit lower too.
Wow, looks like we can have a bet on this question. I'm thinking of who is going to win the bet. So we'll have to wait till the results come out, and we'll have to wait to get an answer for that. But I think people don't really want me to ask questions because they already have started posting their own questions. So I'm receiving too many questions from Vishal is here, and then Raja Shekhar is here, Tamara is here, Chris is here. Oh my God. Too many people. So guys, I would request you to please stay tuned and please keep on watching Immigration and Jobs Talk Show. This special edition, we definitely are going to take up your question, but because I have a lot of questions to ask from you, so now I would like to come to you again, Prashanti, and I would like to know from you, since we are discussing about H1B registrations, so can you please explain the status of the H1B registration process for fiscal year 2025?
So the process is pretty much the same as last time, except for the fact that we now have new organizational accounts, and by now everybody knows about that. Mm-hmm. So these organizational accounts are more robust than the previous accounts. They allow you to have more than one user, you can have more than one admin, and you can have multiple users as well. The connect between the attorneys and the clients also seems to be easier. We got a little bit of a scare on the first day because the website didn't work, and this was predicted. We got a lot of error messages, and then we changed the browser, and it seems to be working better. So maybe right now we don't see any errors, but we did in the beginning. So I'm hoping as time passes and when the final stages of the registration comes to play, we won't see the website freezing or something like that happening, because everyone, we all know historically everyone tries to file registrations at the same time, at the last moment, no matter how much time you give them. So I'm hoping nothing like that will happen. We know that it did happen when registrations first started. The website didn't work for a few days, and then they gave us an extension after that to file registration. So let's see what happens this year. So as of now, it seems to be working. We're doing registrations, and the organizational account, especially to invite each other onto the account, it seems to be easier, and the information that has to be filled out is the same. So yeah, that's my take on the account this year. And of course, you have to remember that the organizational account then will be used to file H1Bs as well online. So it's more sophisticated than the previous account.
Okay.
A follow-up question, Prashanti.
No, sure, please go ahead.
So these online filing of I-129, is it already in place? Do we have instructions and all, or is it expected at some time after this got registered?
Well, it started on February 28th for non-cap cases, and for cap cases, it's starting on April 1st. We haven't used the online system as yet because we want to wait and see. It's like when Microsoft comes out with an edition, right? You don't use it until it's tested. So the same thing. We won't use it, I think, until other people have, because I don't want to be using it and then information disappears. And so I'd rather use the mail for a few days until the system is tested out and we get enough comments on it. But yes, it is up and running for the non-cap cases. There are great advantages for this system, Ranjit. There's no doubt about it. The advantage is that you can e-sign, you can get receipts online, you can get approvals online, you can pay online, and so if someone's status is expiring, you can file it the same day, which would not be possible in many service centers because they don't accept same day mail filing, right? So there are definitely advantages, but we have to wait and see how robust the system is and how good it is with filling out the forms, and whether we would need to fill out the same information in the forms over and over again, or they have a way of, we're so used to using the form software that we have. Each one of us uses a different one, INS, Zoom, Camplake, or whatever it might be. So it may not be as robust as that, but hopefully they'll come up with plugins, maybe these softwares where everything will then be entered into the USCIS system. So we're waiting to see what happens.
Makes sense. Did you get a chance, Prashant Dubey, to explore this option or not yet?
No, I'm not yet, right? And similar to Prashanthi, right? I think attorneys can be very resistant to change, and that's not necessarily a bad thing. For example, the system doesn't accommodate concurrent filings of H1Bs, H4s, and H4 EADs together, right? And we know when someone's going up for renewal or an extension, that's very important to them because they increase their chances of having concurrent approvals. Whereas right now, for filing the H1B application separately, we're breaking apart those applications, which can hurt the H4 dependent. So I think until they build out additional functionalities, it may not be the best system used for filing at this time, or at least something that motivates us to move away from our traditional paper filing. But yeah, for a standalone extension H1B amendment application, it might make sense.
It makes sense. What do you think, John? Do you or the law firm started using it, or how do you think USCIS is going to handle this online filing abuse and be accountable? Unlike many of the times they miss the mail and all. I think you're on mute, John.
Yes. So your question is, will USCIS, how will they handle the online registrations?
Yes, online registrations and online filing. And have your companies, the firm started using the online I-129?
So, having spent time in the government, I've seen them try to implement several different new IT systems that were going to revolutionize the world and change everything. And every single time they fall on flat and fail. So I'm not optimistic that this is going to be a great thing. I think there will probably be a lot of glitches, a lot of bugs. You're going with a low bid contractor on these systems, and they're getting what they're paying for. Actually, they're still paying a lot. So I'm not optimistic that this will be a good thing.
Rajni, you can go ahead.
Thank you so much. So since we're talking about, abuse and fraud, so Yvette, I would like to come to you and I would like to know from you that how have US consulates responded to abuse in H1B applications, like filings without real job offers?
Yeah, but the interesting thing is that the law doesn't require you to have a project to file a petition. All it requires is an offer of employment, and that you promise, as the petitioner, you promise to pay the prevailing wage or the wage on the LCA. USCIS has quit asking for that information because they had a court order against them, and so they're not asking for project information up front. What they're doing is they're pushing it to the State Department to do. And so the State Department's basically enforcing a rule that's been invalidated by the courts. And so even though it's not legally required right now, they're requiring it. And because we can't sue the State Department if you deny our visa, you kind of have to give them what they're asking for. Otherwise, you're just not going to be able to get into the country. So it's going to require some type of documentation of the project. And just keep in mind, they're going to be doing probably site visits, or they're going to be doing verification from the consulate's side, and just, make sure that everything is tight and everybody knows what the process is, and everybody knows what to expect. If they're going to be getting phone calls at the client site or the home office site, just keep everybody in the loop.
Okay. Okay. Thank you for answering the question, John. But Yvette, I would like to come to you and I would like to ask the same question. How have the US consulate responded to abuse in H1B application, like filings without real job offers? What do you have to say?
Correct. So when an applicant goes to the visa window, the consular officer's job is to ensure that they have a real job offer, that they're not part of a staffing agency that is going to quote unquote bench them in the United States, that if the product is being made, where that product is being made, what the product is. So the first thing is that interview. So consular officers are trained to suss out any information that doesn't line up. If this person is a senior product manager, is his wage in line? Is his work location in line? If things are not lining up at the window, then as John said, some additional fraud tools are then used by the consular officer. The first thing the consular officer will do is 221G. Either they'll ask for information or not ask for information. They may 221G for something as simple as an end client letter, and then that letter looks good and you'll get your visa. So that is something they're doing for fraud. That has not changed for quite some time. The way that consular officers look at H1B applications at the window, they're still doing the same things, and they will continue to do the same things even after this new registration process. If there is not enough information from the 221G, then end client verification is then going to be employed and used as a tactic. We're going to also FDNS is a site visit is something that could potentially be used. So those are the ways that consular officers are kind of navigating fraud right now in a nutshell.
Okay. Okay. All right. Thank you for the answer, Yvette. Prashant, now I would like to come to you. I would like to know from you about, the H1B selection timeline and anticipated numbers. So if you can please, this is a question which I am sure a lot of people must be interested in. So when do you think USCIS will announce the selection results and notify employers for the fiscal year 2025 cycle? You're on mute.
How about now?
Yeah, I can hear you.
Perfect. It's not a webinar unless there's at least one technical difficulty, at least with me. So with the selection timeline, I think in order to baseline, right, the registration process opened up on March 6th, and it goes until March 22nd. Once it closes on March 22nd, absent any extensions from USCIS like we have seen previously, probably by the end of this month, we should start seeing those lottery registration selections coming through the pipeline, and employers, attorneys being notified of who is in fact getting selected. So the short and sweet answer is by the end of this month. Hard to say the exact date just because that's always a moving target.
Okay. All right. So people, you have to wait till the end of the month and the results will be out, right? So now I would like to come to you, Prashanthi, and I would like to know from you, regarding notification to employers. So if you can please talk about when will employers be notified and in how much time do they have to file the H1B petition with USCIS after notification?
Yes. So same thing as Prashant said, that the lottery runs until March 22nd. So sometime in between March 22nd and the end of the month, we will start getting in notifications for people who are picked in the first lottery. So because we have to file cases by April 1st, they will notify us before that. It's difficult to say exactly when, which day, but we know historically that they come in over a matter of a few days. They take a couple of days for the notifications to trickle in, and we know that the notifications will come in our online portal, so they'll let us know. And we also know that those cases that were not picked, it'll just say submitted, and there won't be any other notification until the cap season is actually over. So just because it says submitted doesn't mean that it was declined. So as Prashant was saying, there might be another lottery, and if that happens, then you might get a chance in the second lottery. Let's hope. So that's the process for the registration. What was the other question, Rajni?
So I wanted to know, okay. The other question was in how much time do they have to file the H1B petition with the USCIS
Right.
after notification? Yeah.
Right. So you have until the end of June to do it. It's usually 90 days. After the lottery, it's always 90 days. So if you have this lottery, it would be the end of June. And if there's another lottery, then they'll give you another 90 days after that.
Okay. Okay. Ranjit, would you like to ask anything?
Yeah. Quick question, Prashanti. What should a lot of students and beneficiaries who are filing H1Bs have questions like? What should they keep in mind, especially people who have urgent matters to attend to when they want to leave the country, when the registration is filed, or when they have to come back before it's filed, or can they stay back, or how does it work? What do they keep in mind? Regarding going out of country and coming in the country while the H1 registration or the petition filed or about to be filed.
I would say wait for the registration results to come out before you leave the country. Because, it's just better to file a change of status, I would say, rather than file consular processing, because you cannot file, if you're a student, you cannot file a change of status unless you're actually in the country. Of course, you can leave and then come back and then file. You have 90 days to file. But once the H1B is filed, and if you're on an F1, then you have to be aware that if you leave the country while the H1B is pending, then and you have a change of status pending, then your change of status will be cancelled, and they will approve the H1 then for consular processing. So don't leave while it's pending. You can leave after it's approved or before you file. So that's what I would say for those F1 students who want to travel.
Okay, I have a question for Prashant as well. So there is a question from the viewer. He's asking, if you are a foreign worker who has a job offer from US employer, what are the chances that you can boost to get selected in the lottery? Is there any way around?
So the great thing about the lottery is it's a great equalizer, right? It doesn't care who your employer is. It doesn't care about your work experience. Now, what it does care is if you have a U.S. master's degree, right? So there's a certain allotment just for the master's cap. But if you have a bachelor's degree and work experience, and your employer or your petitioner is putting you into the H1B lottery system, you have just as much chance as the next person with the same or similar background, at least from an education standpoint. So unfortunately, there's not much you can do to boost your chances to come out of the lottery. It is a random selection.
Got it. Thank you. I have another question for Yvette. So given this online filing of H1Bs and all, what do you think about, is the process going to be seamless for the consular officers as well to, have an instant view of all the applications, or are the data instantly, and, is it going to make their life better? I think you're on mute.
I think, as I'm going to echo a little bit of what John says about systems and government being very slow, and it's the way that things work on the back end, the way the data is aggregated, what the consular officer is able to see has improved over time, but it improves slowly. So I don't see a lot of change at the visa window. I think the scrutiny will be there. I think fraud will evolve. It will may reduce significantly due to the fact that there's not going to be duplicate applications, but it'll still be there. It'll look different. But in the data collection on companies has improved over time. Access to historical records, companies who have had FDNS site visits and such, we do have, consular officers do have access to that. Hopefully that'll improve over time. But scrutiny at the window, fraud, it'll always be there. I don't see the process at the window changing much.
Okay, thanks. Rajni, you can go ahead.
Whenever either USCIS or government is being mentioned, Prashant has a big smile on his face. So
it's only because we all have such good things to say about USCIS and their use of technology. That's why I'm smiling.
Okay. Well, no pun intended.
Yep.
All right. Okay. So, John, I would like to come to you. I would like to ask you about H1B self-petitioning by beneficiaries. So, what are your views on H1B self-petitioning by beneficiaries, especially in scenarios where beneficiary owners may be eligible for H1B status under certain conditions?
Yeah, although you're eligible under certain conditions, just know that it's going to be a massive red flag right off the bat. So they'll be giving your petition way more scrutiny than anybody else's. And when it comes down to it, there's one question that's going to be very difficult for applicants who are self-petitioning to overcome, and that is, you own the company, you're doing management. Management doesn't require the technical, specialized knowledge.
Mm-hmm.
So how do you qualify for an H1B if you're a manager? And so I think that's the problem that a lot of people will run into, even if they, click the right boxes and jump through the right hoops. They're still going to have to deal with that issue.
Okay, all right. Thank you for answering the question. Looks like a lot of viewer wants to ask questions from the attorneys. So I would like to. Okay,
Let me ask one question. That's
sure, please
hovering
go ahead.
around here. Someone is asking, is it okay? This is for Prashanthi Reddy. Someone is asking, is it okay that they can leave country while perm is in process, or what someone should keep in mind? If the perm is in process.
That's
I'm so
absolutely
sorry. I'm
fine.
really sorry to interrupt. I'm really, really sorry to interrupt. But because our viewers mean a lot to us, so I would like to also give out their names, and also would like to pose their questions on the screen so that they know how much we value them, and we get one more subscription. So if you can also name the person.
Yeah, I think Ame Mirza is the one who's asking the question. Like,
Great.
at what point of time in perm application should we not leave the country? Is it okay to travel or not?
It's absolutely fine to travel while your perm application is pending. You can travel at any point of time, actually, throughout your green card process. The only thing to keep in mind is that if you filed a 485, since it's not family based, it's employment based, you can travel back on a H1 as well. You just have to make sure you have the means of traveling back. You have a visa or something like that, because if you have filed, so just to backtrack, the PERM is the first step, and then you have the I-140, which is the immigrant visa petition, and then you have the 485, which is adjustment of status. So if you're in the country, these are the three steps that you'll most probably follow, and there's no issue traveling while you're on while your PERM is pending or your I-140 is pending or approved. When your 485 is pending, then you have the opportunity of traveling either on advance parole, or you can travel on a H1. And USCIS has said many times that even traveling on a H1 doesn't in any way invalidate your 485 petition. So you just have to make sure that you have a way of traveling back, you have a visa or an advanced AP approved before you leave the country, and it should be fine. Either way, you can travel on all three statuses.
Thanks, Prashanthi. Rajani, you can go ahead.
Okay, so I think we can continue taking the questions because we have a lot of questions from the viewers. And if I continue asking my questions, they'll be, upset.
Okay.
So let's
Let's
not upset them.
with the
Yeah.
next question.
So I think we have a question from Chris.
Yeah, Chris, what is the number of visas expected to be issued this year? Prashant, if you can take this question.
Yeah. So if we're sticking to the topic of the H-1B lottery registrations, right? So for the kind of normal cap, we've got 65,000. For the master's cap, we've got 20,000. Now, the historical trends, what they've told us is that the number of selections always exceeds 85,000, right? And they will always select more than 85,000 individuals because of that funnel effect that I talked about earlier, right? So over the last several years, it's always been 100,000 plus that have been selected. And the reason why there's a funnel effect is because maybe only 60 or 70% of petitioners will then actually, apply for an H-1B petition for the beneficiary. So that's why we end up seeing, that second and third H-1B lottery sometimes take place, because you always end up with more lottery selections and H-1B visas being issued than that 85,000 cap. And this has happened every single year since that online registration has opened up. So I think, from a selection perspective, we'll probably see 100,000 plus, maybe 120,000. But then, USCIS will land somewhere close to that 85,000 number.
Okay. Yeah, Ranjit, would you like to add something, or would you
Yeah,
like
there's
to?
another question, that I want to ask Prashanti Reddy. I'm currently on H1B and it's approved until 2025, and I'm residing in USA. I'm not confident on my further H1B extension gets approved. Can I apply H1B in consular process? I think you're on mute, Prashanti.
Sorry, I should try and remember that.
Yeah.
Basically, yeah. Sorry, what did you say, Ranjit?
Yeah, the question is from Harish from LinkedIn, and he's asking his H1B is approved until 2025 and is in USA, and he's not confident his extension gets approved. So he's asking if it can be filed as consular process.
Of course, you can do whatever you want. You can file for consular processing, and if you already have a visa, existing visa in your passport, then you can use that same visa to come into the country. If your visa is expired, then of course, if you are filing for consular processing, you have to leave and then come back on a fresh visa. So yes, absolutely, you can do that.
Okay. Yeah, makes sense. And coming to the next question, there is a question from Facebook. Mahbub is asking, as the H1B lottery system evolves and potentially faces changes in 2025, what strategies should employers and foreign workers consider to enhance, obtaining H1B visas, and how can legal counsel best navigate these changes to optimize outcomes for their clients? If John, can you take this question?
Yeah, sure. So really was mentioned earlier, the lottery is a great equalizer. There's really nothing you can do in the current system to game the system to increase your chances of selection. The only thing you can do is you can get a master's degree from a U.S. qualifying institution that allows you to be in the master's lottery and the bachelor's lottery, so you get 2 bites of the apple. That's really the only way that you can up your odds of getting an H1B these days.
Thanks. Coming to the next question, there's a question someone is asking. Chris, this question goes to Prashant. How is the prevailing wage determined?
Yeah. So there's a few different aspects of this, right? You get a prevailing wage for the perm process. There's also a prevailing wage as a part of the H-1B labor condition application, right? And basically what the Department of Labor is looking at is how are other similarly situated professionals in your specific geographic area with your years of experience, with potentially your educational background, bachelor's, master's, what does that look like? What are they earning? And it's very much a geographic determination, and they kind of aggregate statistics and data across the board from individuals within that same profession. So, for example, when we see a prevailing wage determination issued by the Department of Labor as a part of the perm process, those are all of the factors that they're considering when making a determination on how much is this person supposed to be paid for the job that they're doing, right? And for the H-1B, you have things like level 1, level 2, level 3, level 4 wages, which is you can make that determination based on the years of work experience someone has and their educational background. But the back end data is based on a specific geographic area or region, that is very specific to your occupation or profession and the number of years of work experience and education required by the job.
Thanks, Dubai.
So I'm so sorry to interrupt, Ranjit, but before we go ahead with more questions, I'm sure people are going to be upset because I'm again, interfering into their questions, and I'm asking my own questions. But then, Yvette, I would like to come to you, and if you don't mind me asking, because I'm sure that people are really enjoying asking their questions. But then, Yvette, I would like to know from you if you can please, we would like to talk about IT and market slowdown. So, if you can please talk about considering the IT and job market slowdown and changes in US CIS and US DOS policies, what advice would you give to H1B aspirants for approval? Yvette, you are on mute, but I would like to unmute you if I can.
I'm so sorry. That's really rough to remember that. So, regardless of the IT job market slowdown or USCIS policy at the visa window, the advice is to come to the visa window prepared. And I think there's a question on that later, but essentially having your I-797 being able to answer questions, but also don't from the very onset, especially. So I will give advice to those students don't link up with companies that are shady on OPT and CPT. We have seen how that has panned out recently in the media, and that can cause a ban for life and a black mark against you. So don't do that. And if you are going for a company as an H1B, make sure that the company doesn't have any history of fraud, because there are black marks on those companies, whether that is allowed or not. That is a reality. So do your research. If you know somebody who has gotten a revocation with that company, think twice, look into why that person was revoked and whether or not it was a fluke or if this is a standard for the company, because automatically you will face scrutiny at the window. You don't want to go through all this for you to end up with a 221G, possible revocation, possible misrepresentation at the window. So credible company, do your research, and don't engage in fraud are definitely huge things for that last stage.
Okay. All right. So thank you so much for answering the question, Yvette. Ranjit, please go ahead with your questions.
Yeah, Prashant, there is a question from a viewer, Sheena Sheikh. It's from YouTube. She's asking, I have an H1B stamped for 2022-23, but I didn't travel because the employer made multiple registrations and has not responded since I got my visa. I see the status of visa as revoked. Can I apply for this year? Are there any issues if I do?
So here's the thing, right? You can apply for you can find a new employer sponsor, a new petitioner. You can apply for the H1B lottery system again, especially if your previous H1B was revoked. Just keep in mind, this is in your record, right? The fact that USCIS had to go back and revoke an H1B petition due to duplicate filings, right? Now, this may be due to no intention on the part of the beneficiary. Perhaps the petitioner had multiple sister companies, and the same person from HR submitted multiple registrations from two different sister companies for this individual, and this individual had no idea. At the end of the day, and perhaps Yvette can speak to this, a visa officer is going to end up making that determination of facts to see if there was any fraud, any misrepresentation, or any attempt to game the system on the part of this beneficiary. So I'd say you can definitely do it. Just keep in mind that this is kind of a demerit against your immigration record.
Yeah, going back to Yvette, what do you think, Yvette? What might U.S. consular officer keep in mind since the visa is already revoked?
Yeah, I would definitely get with an immigration attorney that is really well versed in that space. If you do have another registration, if you show up at the visa window again, exactly, it's in your record. So you want to have documentation of what happened the last time and ensuring that you have a credible job with a legitimate company for the next time, so that you can hopefully clear yourself of any wrongdoing and not get any misrepresentation hits the next time you show up at the window. Just because you don't currently have anything regarding misrepresentation, that it's just a revoked visa, doesn't mean that consular investigation won't happen and you won't end up with an ineligibility once you show up to that window again. So don't go unprepared. Definitely seek immigration advice from somebody very well versed in this field and be prepared on both ends. And hopefully, if you go through the registration, you have another employer, you can be clear about what happened, and they can also help you through the process. So I don't know if anybody else wants to add to that complicated question.
So I'll say
Hello, gentlemen, ladies. How you doing?
yeah, so there's a ray of sunshine here on this registration issue. And what we've seen in court of litigation is when we've challenged the fraud finding in multiple registration cases, it's been applied to the employee. In every single case, the government has issued a declaration absolving the employee of any fraud. It said, you're not guilty of fraud because it was somebody else that did registration and made this statement to the government. So that's a positive sign. I think they're moving away from penalizing the employee in that circumstance and just focusing on the employer's actions.
I just want to add, consular processing can be very brutal, meaning that logic may not always prevail. I know that John knows this. The applicant may incriminate themselves unknowingly at the window. The consular officer may not have any of the facts that John just mentioned. So going in there with documentation, a letter absolving them of any wrongdoing, being well prepared and prepped is very important going up to it, because it's very easy for a consular officer to ignore all the facts, slap a 6-1C, really not give that applicant a benefit of the doubt, because all the consular officers see is pass or revoke petition. This is a bad guy. That's what the consular officer, and they don't have to justify what they're doing too deeply. And once you have that misrepresentation, it's very difficult to backtrack and get that off your record. So do not get stuck in that position.
Thank you.
Hi, John and Yvette. I have a question. This is Dan. I'm on a call. Now, you just said consular officers, right? You know, how consular officers can decide in 30 seconds or a minute. Is this fair? You know, we have, you know, attorneys here on the session, spending hours and days to, you know, get an application approved. And John is a guy who, you know, who goes with litigation with the USCIS. Now, what does it take for an officer and approve or deny in about a minute?
Is it fair?
Is that fair?
I don't think. I think it's a kind of a ridiculous situation.
No, I just want to ask, you know, Yvette, did you get my question?
It's absolutely not fair. I mean, I started my company Udeti. I do visa interview preparation because it's so unfair and because applicants can incriminate themselves. And in this situation, they can get an ineligibility without having that new, if they have a new job, that new job may not even need to be revoked. That new petition does not need to be revoked. They could be refused just based on an ineligibility if they go up to the window and incriminate themselves unknowingly. Everybody that goes to that consular window, English is their second language. They're very afraid. And so they could say something like, maybe I knew that company wasn't real or something like that, and automatically it could be a misrepresentation if the consular conversation goes awry.
Right.
So that
So
it's not
Prashanti, let me ask you a question. How many labor hours it takes to file an H1B petition, roughly?
How many hours? Oh, how many hours? About maybe 3 hours to file a H1.
And then from the employer, you know, trying to get an employee and then going through this process, right?
Right.
Maybe for the and then how many hours John has taken to fight this case with the the resigning the employer-employee relationship, and then the so-called ID server memo.
Right. So I think your point, Dan, is that everyone spends so much time on each petition, and then when the goes to the visa office, the question is how much time does the officer spend on looking at the case, or how much time do they have to look at each case, and how thoroughly do they look at documentation, and do they take second opinions before they process a particular case? I think, Yvette, maybe you would be able to enlighten us on what the process is. And
So,
what training, what also another question is, what kind of training they receive to determine whether a particular petition is a
oh
valid
my God,
petition.
really, really tough questions. Consular officers see so most consular officers have never seen an H-1B before they arrive to certain countries that have a plethora of H-1Bs, like India, for example. So everybody is very fresh in learning, and a lot of the learning is internal. Like, I created internal processes for the people coming behind me, for example. So there is some training. It's not as easy as denying a B1, B2, because you actually have to revoke a petition. So there is a lot of processes to look into it. So in a way, it's not completely unfair. The H-1B process is not completely unfair. What we're talking about here is a situation with a past revocation that could potentially turn into a misrepresentation charge. That can go sideways very quickly in an unfair way. But in general, when consular officers are adjudicating an H-1B, they can't just refuse you for 214B. They have to do some due diligence. So I think 221G can be unfair if it takes a long time and it causes you to lose your job. And that's kind of a snag in the system. I hope I'm kind of making myself somewhat
Yeah, there's a
clear.
lot of snags in the system though. So John, I still have a question for you. Now it's a beneficiary centric process, right? And how is this going to affect the American workers? Because there's, USCIS is still going to collect fees. Now, let's say, they still have, I see on Facebook, LinkedIn, a lot of, people are still paying money, the same old story, and trying to get although they don't understand that it's beneficiary centric, probably they'll have duplicate passports, duplicate passport numbers. And, I think, in my opinion, this is going to be worse. USCIS will get billions of dollars, right? Same old story. How are you going to combat this?
So USCIS will definitely take their money. That's the one thing I know about USCIS. The only thing they do actually effectively is take your money. So that's going to happen. The likelihood of it blowing up into more fraud and more abuse, I personally think it's low with the current system that they're putting into place for this year. So I'm optimistic that we won't see a continued explosion of fraud findings due to lottery issues.
All right. Rajni, go ahead with your comments and questions. Thank you.
Looks like not just our viewers are enjoying, but our own team is also enjoying the show. So which made Dan join with his questions. So now, Ranjit, would you like to take next question?
Yeah, sure. Prashant Reddy, this question is for you. Rashmi from YouTube, she's asking if 2 employers can file H1B application this year.
Yes. So the way it's going to work is beneficiaries, of course, can always file multiple registrations. Employers cannot, have never been able to file multiple registrations. Not only that, employers cannot conspire with another employer who they know and file a registration for the same person, right? And then seek to share the profits. So that's not possible. But a beneficiary has always been able to file multiple registrations as long as each registration has a valid job offer, right? So there has to be a valid job offer for each registration that you're filing. So that's one thing to keep in mind. Now, once this happens and a beneficiary is filing multiple registrations, they will obviously get picked. And then when they get picked, all the employers that filed for them will be notified that your registration was picked. So now there might be 3 employers that filed a registration for them. All of them will be notified once their beneficiary is picked in the lottery. Then all of them will be able to then file a H1B petition for them. And it really doesn't matter which one is filed earlier or which one is filed later or which one is approved later. They can choose which H1B employer to go with. Now, I'm thinking, and this is because, historically also, beneficiaries can file multiple H1Bs with different employers. And USCIS is doing this, I guess, to promote competition. So a beneficiary also can pick and choose, which employer is giving them, the best, I guess, the salary or whatever it might be, benefits, et cetera, et cetera. So I guess USCIS has always done this and is doing this to promote competition, and that's the corporate way, Dan, whether you like it or not. I know employers won't like it, but that's what it is. So to answer your question, yes, 2 employers can file for a H1B application, and then the beneficiary then can decide which H1 they can go with. And later on, if the second employer wants to continue with the job offer, they could possibly file a concurrent H1. So that way, it is possible for the beneficiary to work for more than one employer at a given point of time.
I have a follow-up question here. Now, as in the maybe this is for Prashant or everyone here, right? As in the green card application process, where is the you file an LCA and you just get the LCA approved, and now we're talking about last year 780,000 plus applications. So is this not affecting the U.S. workers? And Yvette, what happens at the consulate? Are they really looking at the visa officers? If someone is here, they get a change of status and they get the petition approved. When they, this is a circle around question, right? Now, what happens? Now there are 300,000 jobs. What they're claiming, but then actually, where are these jobs? The people, American workers, like the U.S. citizens, green cards, put in a limbo without jobs, and then these employers are filing 300,000 cases. Maybe John can take this, right?
I think the problem there is the shortage in qualified, able U.S. workers. With every passing year, the number of U.S.-born students in STEM degrees, especially master's degrees, drops, and the percentage of foreign people getting those degrees in the U.S. increases. So I just don't see U.S. workers being hurt by this program because we just don't have enough of them to do these high-end, high-skilled jobs.
Okay.
I would even add something to that, right? If you look at a very granular level, right, at very big companies, there's a shortage of solutions architects, right? Solutions architects and that technical background is almost a prized skill set that companies are looking for, right? And to John's point, if we were able to fill those roles with American-based workers or American-born workers, Congress probably wouldn't have mandated, the number of H-1B visas that get sent out every year, right? And that's speaking just from, through my clients, right, who are looking for those types of skill sets and are often sponsoring those types of skill sets, and they just happen to come from, a certain number of countries.
Thanks, Prashant and John. John, I have a question for you. This is kind of very, what is a lot of people are facing this. How do you think it's fair, that the green cards are based on country of birth? When H1B is, they were never capped it at country quota or country of birth, but since last 20 years, a lot of green cards have been piled up, and it's, I believe, about 1.5-2 million people that are waiting in line, especially from backlog countries like India, China, and other countries. How do you think it's fair? And I know it needs a congressional insight, but then it looks like it's going nowhere since last 10 years. So I know you've been part of lots of litigations, that can ease the pain of a lot of people. So how do you think the system is fair, and what are some of the actions that you are doing on this?
Yeah, the system is horribly broken. You have 85,000 H-1Bs coming in each year that will eventually be looking to get green cards. 70% of those, 75% are from India. The number of people where we're oversubscribed for Indian visas balloons with every new lottery and with every new year of H-1Bs. So it's got to change at some point, and Congress has to step in and do it. The sad fact is that the per country limit has its origins all the way back in the Chinese Exclusion Acts back in the late 1800s, early 1900s, where they were trying to limit how many people from China could get here. So they throw this limit in there. And now that limit is being applied to skilled workers, where it was originally to unskilled workers who didn't speak English. So the purpose for it is just gone, and it needs to change.
I also believe that a lot of people have a lot of insights, but a lot of people say that there is no statute saying that dependents should be counted against visas. Some say yes, it's there, and there are also some lawsuits that were initially initiated or something, but it never went anywhere. So, do you have any insight on this? Or
There were EB-5 lawsuits challenging the counting of dependents versus primaries, and the plaintiffs lost all of those cases. I think that's something that is in the discretion of USCIS to determine. And as long as they have a process and it's in the regs, courts are going to enforce it and are going to allow it. So I don't think there's much that we can do through litigation. One thing I would hope they would consider in regulation is consider, since there are some visas technically available, when you get your green card, when you get your 485, you can file it immediately with your I-140 so that you get your EAD, advanced parole. And that would give you all the benefits of a green card while you wait for this interminable amount of time.
right. I think there is something called I-140 EAD, but there is one word that's inserted called compelling circumstances that that makes it tough for everyone to file. If that just one word is taken off, everyone that has an I-140 can file an EAD. It's very simple.
Yeah.
It makes sense. Yeah. Our next question, Prashant. I have a question from the caller Praveen from Facebook. He's asking his H1B got picked in 2020 and got approved, but never got the visa stamp. He's asking if that H1B can be used and transferred. If not, can he file another H1B this year?
Yeah. So if his H1B visa was never activated, that might pose a problem in terms of doing an H1B transfer. For this one, we would just need a little bit more information, a little bit more facts to properly answer it, just because it is so nuanced, right? For example, was the H1B petition revoked at any point, right? Did that employer revoke it, prior to potentially its effective date? So I don't think we can properly give him an answer unless we know a little bit more information here.
Okay. Viewer Praveen, if you want to connect with an attorney, you should get a consultation. I have a next question for Prashanti Reddy. One of the viewer Pavan is asking, how does USCIS know if it's fraud or multiple petitions filing? Do they at any point of time go, let's say if multiple are selected, do they ask for the offer from each and every person to make sure that offer is legitimate?
So when you're filing a registration, USCIS has said that the job offer has to be a bona fide job offer. I haven't seen USCIS go after these people, the registrants, and I have not seen them ask for additional documents. But they say that you should keep everything ready. So we usually advise our clients to have an offer of employment, if it's an employer, to have an offer of employment signed with the employee before they do the registration. And also, if they're not going to be then filing the H1, and if their registration is picked, then have some documentation to show that the beneficiary did not want to take up the offer, or they had a different offer, etc., etc. So it's important to maintain documentation so that we can be ready if USCIS asks for anything. But from what I've seen, USCIS has not been asking for that information.
So thank you so much, Prashanti. Before you take up another question, Ranjit, I saw a comment posted here. Someone was saying something, whenever someone starts making sense, I don't know, the trolling starts to happen. This person is saying, who is this, asking questions. He doesn't understand the process at all. I think he was asking pretty great questions. Don't you all agree?
I agree.
Right? So
Yeah.
I think this particular
That's
person
uncalled
is
for.
a bit jealous.
These
that
are-
he's
these
not
are
making
basically-
sense to
here.
questions.
Yeah, these are just questions that will force you to think about the present system and
Right.
try and strategize and see if there's anything we can do to make changes. And it's important to ask those questions.
Of course.
Yuvat, I
Well,
have similar question for you regarding the same thing. How do you think the consular officers know about multiple registrations? Let's say if they are somehow missed by USCS, do they get into more details of if someone has filed multiple and got away with the system?
No, we don't know if there's multiple registrations, if a registration was not revoked, if a petition was not revoked in the past, something like that is very clear. But we don't have information about multiple registrations or the back end. But how this makes consular processing more difficult a year like this year, if there's multiple registrations, obviously it increases the number of fraud. So hopefully next year there will be less fraud because we will have more genuine applications and not one person filing like 83 times. And so the way it affects the window is now all H1Bs will be under more scrutiny because consular officers worldwide is seeing more H1B fraud at the window. FDNS is backed up, and it just creates a ripple effect in terms of fraud. So hopefully next year some of that fraud will be reduced, and it won't be. Does that make sense? In terms, it'll be more scrutiny. The more fraud we see at the window, the more scrutiny that day in and day out is going to be happening at the window.
Thanks, Yuvat. Prashanti Reddy, I have a question for you.
Ranjit,
Just
before you go
wanna-
ahead with the question, I'm again sorry to interrupt, but then there was this viewer called Rashmi Prajapati. So Rashmi, if you're still if you're still tuned with the episode, so I would like to tell you that in the last episode you had a question regarding green card. So I would like you to connect with me. You can send me an email on rajni@higherightpeople.com. We'll be glad to help you. Ranjit, please go ahead with your question.
Yeah, I have a question from viewer Jitendra Jain on LinkedIn. He says his extension of H1B has expired in 2017. Is he still eligible for H1B renewal? It's been more than 6 years, but he somehow was on H1B for some time and not utilized 6 years of H1B.
So the question I think here is whether he's cap subject or he's cap exempt. If you're cap subject, then you obviously have to file under the cap. But if you've already been on a H1 and if you've, I see that it's been approved. It doesn't say whether he was actually in the US on a H1. But I would say that if you've previously been on a H1 within the last 6 years, then you possibly could be cap exempt and you possibly could file an extension even if you haven't come into the country. But since it's more than 6 years, 17, 18, 19, 20, 21, so it's more than 6 years looks like. So I would say that you'd have to file a new registration under the cap.
Yeah, it's kind of a tricky question. It depends on if he has been on US and had some worked on H1B. So I would say, Jitendra, you have to either give elaborative question or reach out to the attorneys. He says he utilized 1 year of 6 years, so that means he was an H1B for 1 year.
Right, but since it's been more than 6 years that he was last on a H1. I don't know when he was last on a H1. Maybe if it is 2017, then it's more than 6 years. Then if it's more than 6 years, then unfortunately he won't be cap exempt anymore, because as per the regulation, within the last 6 years you should have been counted towards a cap. So if you keep that in mind, then he might not be cap exempt. But again, USCIS has been all over the place about who is cap exempt and who is not, and how they define it. And they've been more liberal at times and less liberal at times. I remember a few years ago when I was filing a cap exempt petition for a person within 6 years, but he was never on H1. They said that it was not cap exempt. But recently, when I've been filing cases, as long as they're within 6 years, even if they have not been working on a H1 before, they have found them to be cap exempt. So again, I think it's case by case, but we have some borders within which I think we operate, but in general, it depends on the circumstances.
Right, John, I have a question for you. What do you think about this? There is USCIS is a lot of times very vague. Sometimes within the law they say 6 years, used, unused, recapture, a lot of stuff. What do you think about this?
So the cap subject piece, the way I read the statute is, if you've been counted against the numerical cap one time, you don't need to go back into the lottery again. So I think if you were in the US on an H1, you were selected in the lottery, you were counted against the numerical cap, I think it should work out for you to get a new H1B without having to go through the lottery.
Okay, thanks. Prashant Dubey, I have a question for you here. Someone is asking, Chandra is the name, and from YouTube. Should I file a green card while STEM OPT is pending? Would that create any issues? I'm planning to file for a green card at the end of my initial OPT, then file a STEM OPT. So,
okay. So there's multiple routes to a green card, right? So this could be a family-based petition. We don't know if he's getting married to, a green card holder or a U.S. citizen. This could be potentially an employment-based petition, and we don't know if he's got an employer sponsor or if he's trying to self-petition in the EB-1A category. So let's say this isn't a family-based petition. And let's also assume this isn't an EB-1A self-petition. And he does, in fact, have an employer sponsor with the current employer he is working with. You can start the green card sponsorship process, right? Prevailing wage determination, perm labor certification, I-140 application, and then going through the 485 if your priority date is current at any stage. You don't need to be on an H1B or an L1 or anything of that sort. Even students on F1, if their employer, right, while they're on OPT or on a STEM OPT, if their employer is willing to sponsor them for it and go through that process, nothing is stopping them from doing so, right? And so, that process is going to be independent of their STEM OPT extension. They can continue with that and still have that perm labor certification process happening in parallel. I see no issues with that, as long as his employer is willing to sponsor him through that process.
Thanks, Prashant.
All right, so we have one more question from, I think it's a follow-up question from Rashmi Prajapati. So would you like to take it, Ranjit?
Yeah, sure. The question is, currently if someone is in USA on student visa and pursuing masters, it's been 4 months from admission. If I get selected in H1B cap exempt, is it required for me to travel back to India? Prashanti, can you take this question?
You could file a change of status, and if the change of status gets approved, then you could possibly be on a H1, as of October 1st, and you don't have to travel immediately if you don't want to. The only time that if you want to travel, then at that point of time you'll have to go get a visa at the consulate, but otherwise you can file for a change of status and remain in the country and change seamlessly from an F1 to a H1.
Thanks, Prashanti. Let's take another question.
Well, we have last 13 minutes to go, I think. But too many questions to take, right, Ranjit?
Yeah, we only have 15 minutes actually, I think, right?
Oh, 15 minutes. Right.
Okay,
So,
the question is from Girish Kumar. He's asking, and it's from YouTube. Prashant, this is for you. If the perm PWD comes in before H1B renewal, do they have to pay me the salary when my H1B visa is renewed?
Can you repeat that question?
Yeah, basically it's perm and H1B. So if the perm PWD comes in before the H1B renewal, do they have to pay me the salary when my H1B visa is renewed? Is perm the wages in perm linked to H1B anyway?
Yeah. So essentially, the perm is a promise of a future job offer, right? So when that prevailing wage determination is issued, the employer is basically saying, hey, once this individual gets his green card, these are the wages that we're going to be paying him. Now, the H-1B wages might be slightly different than the PWD wages, right? And that's completely fine. Maybe the PWD wages are slightly higher than what somebody's being paid on their current H-1B wages. There's no requirement that during the H-1B renewal process that those wages need to be absolutely the same. Now, when that person is eligible to get their green card, they need to be paid as per their PWD that was filed in the perm application. So at this time, if the employer decides, hey, we're going to keep you on your current H-1B wage, that's completely satisfactory. But at the time of that individual getting their green card, they do need to be paid their PWD wage.
okay. Thank you, Prashant. Yvette, I would like to come to you. So if you can please answer what happens at the consulate if someone was not paid and at a consulate for a visa.
So the scenario is they're coming for a H-1B stamping and they have not
Yeah,
been
no pay
paid.
stubs. Yeah,
Yeah.
basically
No
they don't
pay
have pay
stubs.
stubs, let's say, for last couple of months or so.
So consular officers don't always ask for pay stubs. They could also ask for your tax returns, and they do routinely ask for your tax return to make sure that what is listed as your wage is actually getting paid to you. If not, they're going to look into that, and that could be potentially a revoked petition based on not following what is outlined in the petition and the labor certification agreement. And so that could potentially end up being a revocation. So additional information would be asked: taxes, pay stubs, then and client verification could potentially be done, FDNS site visits, and depending on what is happening, it could lead to a revoked petition or some. It could lead to a revoked petition if that job was not there or if they were not meeting the conditions of the labor. But I think Dan would probably have seen some consequences on the back end. I don't know if anybody else wants to jump in, if they've seen what the consequences have been, if it was always as severe as a revocation, or if it could have been like potentially a slap on the wrist and some writing to the Department of Labor, some flagging to the Department of Labor, but eventually it could have gotten resolved. So I'm not sure who's seen that on the back end and what other consequences there may have been.
So I've seen attempted revocations where they do a site visit. The most egregious example was the LCA said he was to be paid $120,000. He gave him this W-2, and the W-2 said 119. There's a lot of reasons why that could be legitimate, and they sent out the notice for intent to revoke. Structurally, the way the statute is set up, it's not a status violation if your employer doesn't pay you. What it is it's a civil liability on the employer. You can sue the employer for back wages, and the Department of Labor will enforce that. And so, I've seen this a couple of times when we've pushed back, and each time they've not revoke the visa, because I think they realize that they're on pretty shaky grounds. But that doesn't mean they won't keep trying it.
A follow-up question on that, John. A lot of employees face this kind of issue where employers don't pay them what they are supposed to be paid. How do you think employees can handle this situation?
Well, under the statute and the Department of Labor rules, you file a complaint with DOL. DOL then will investigate, and if they find that the employer hasn't paid, they'll give the employer an order to pay.
Is that going to impact their status or application in any way? That's the fear a lot of people have when they want to complain, to government agencies.
So that's the problem, right? Is that Congress created a system that is complaint-driven, employee-driven, and so USCIS has flipped that over and said, "You're not getting paid. That's your problem. You violated status through no fault of their own." And so what USCIS is really doing is they're taking away any incentive employees have to cooperate with the agencies and report employers that are breaking the rules. And it's maddeningly frustrating. But much of what USCIS does is maddeningly frustrating.
Thanks, John. I have a question for you, Prashant Dubey. This lot of people ask me this question, and it's on a lot of people's mind. So a lot of students have start applying the H1B since the chances are low, even from the initial OPT. So they have couple of years until they get an H1B. So the question is, since they always have 2 or 3 years of OPT which they can utilize, can they file an H1B in consular process and just continue on the OPT and go back to the H1 only when they need? You know very well that students have more tax advantages than when they are an H1B. So can they use this option of filing it in consular and get back to an H1B later after a year or two when their OPT expires or OPT is done?
Yeah, I mean, there's nothing stopping them from continuing on their OPT, right? You need to be very careful in how you work with your employer, because the employer on the I-129 petition, they're going to, very clearly state that this is a change of status or this is something that needs to be approved in consular processing. So if they do it in change of status, that thing is going to go into effect on October 1st of this year. If you do it in consular processing, then in order to activate your H-1B, you do need to go to your home country. Let's say that's India, for example. Attend a visa appointment, and then get your visa stamped for your H-1B. Enter the country on an H-1B in order to activate it. So if you wanted to defer your activation of sorts, for tax purposes or to fully utilize your OPT. Maybe the OPT has a little bit more flexibility than the H-1B does, right? We've seen that in instances too. The H-1B employer might be someone different than who they're working with right now. So different strategies can be implemented to defer the activation, but that is totally fine as long as it's in consular processing and not a change of status.
Same question, John. Is there any regulation that's preventing them from doing this, or it's okay to have them continue on their OPT even when H1B is picked and use it later at some point of time when their OPT is done?
So I would say that the answer that Prashad just gave was right on. I think that's there's nothing more for me to add to that. So.
Okay.
Okay,
Prashant
so
Reddy.
I'm so sorry. Looks like I'm really good at interrupting, but I'm really sorry, Ranjit. I would like to come to you, Prashanti. Prashanti, I have a question from the viewer for you. So he has posted this on Facebook, Amol Kadu, and he wants to know, I applied for TN earlier and they asked me to withdraw it. I'm looking to file H1B now. Is this action will have any consequences? What do you have to say?
I don't see. Well, it depends on why your TN was withdrawn. I guess you went at the port of entry. There might have been some documentation that was not submitted, or something that happened there, and then maybe the officer at the port of entry asked you to withdraw the TN. We don't exactly know what the circumstances were, but if it was something reflecting you. That is, there was there was some problem with your education or something that you misrepresented, then it's definitely a problem. Whatever petition you apply for, that will be a black mark. So it really depends on if it was an employer based issue, then if you're filing through another employer, then you might not have that same problem that you had earlier when you're filing for a H1 at the consulate. So it really depends on what the circumstances were.
Okay. Amol, I hope you have got the answer. Ranjit, you may continue, please.
Yeah, Prashanti Reddy, I have a question. The same question that I was asking Prashant. So, can they when they use this opportunity to defer the the H1B activation at later point of time instead of consulate process, can they use a change of status, filing again and without leaving the country? Can they continue on the H1B?
I don't see a problem with doing that. You can definitely hold on to that H1 approval and then go for a visa at the consulate a year later, as long as you have a updated job offer letter from your employer, and as long as the offer is still available, and as long as the employer still has work for you and is able to show specialty occupation work. The consulate obviously, and Yvette will speak to this more, but the consulate will obviously ask if the employer still has work for you, because it's been a year since the H1 was approved, so they might ask for that information. So I would preempt
Most likely
that.
would
And
work for someone who is working for the same employer, let's say.
right. If they're working for the same, it still doesn't mean that there is a valid job offer. So I would still carry an updated employment letter and proof of employment, etc., to show that that job offer is still valid and is still open.
Thanks, Prashanti. I'll hand over it to Rajni.
Thank you so much, Ranjit. So now, looks like we can go for another 2 hours, but then, we have last 3 minutes to go. So I would like to ask each one of you, what would you like to say about any golden word about H1B fiscal year 2025? Let's start with Yvette. Yvette, what do you have to say?
The unprecedented number of registrations last year was shocking, considering how the system was being administered. I am feeling really positive about the new changes so that duplicate registrations are not happening. Hopefully this will reduce fraud, and I don't see how it could not reduce fraud. I mean, not eliminate it, but certainly reduce it, which is a really positive thing for USCIS, consular processing, FDNS, and all of the other channels that have to deal with fraud. So my final advice is don't engage in fraud. It can go back to haunt you. And H1Bs are important. CPT, OPT is important. We have to continue to advocate for CPT, OPT, and H1Bs for our international student population, for the economy of our university, for the US economy, for diversity. So thank you so much for having me.
Lovely. Thank you so much, Yvette. So, Prashant, you can continue smiling. And any last message and any golden words for, H1B fiscal year 2025?
Yeah. So
Sorry, was that Prashant or Prashanti? I'm always confused when you say
Okay.
The second time I got confused with whether it was Prashant or Prashanti.
Okay, since, you already started the answer. So, Prashanti, you can go ahead. Then we can go to Prashant.
Sorry about that, Prashant. I didn't mean to cut the line.
Yeah, ladies first.
So, we all know about what's happening with the H1B program, right? There are many issues. I mean, of course, that the issue that we faced last year with multiple registrations, that was a unique issue, and that was just ridiculous. It endangered the entire registration process itself. But even if that is fixed, and hopefully it'll be fixed this year, there are many more issues that have not been fixed. One is just the number of H1B, the cap. The 85,000 cap is compared to the demand, we see that only 20 to 30% of petitions are picked. So this means that the US economy is telling us something. It's telling us that there is a shortage of people in the sector. And so, we need to increase the numbers. And this hasn't happened, and I doubt it'll happen soon with the partisan politics that's going on. So everyone, each party wants to be one up on the other, and whatever. So I don't think anything is going to happen with the increase of the H1B numbers now in the near future. Also, with reference to specialty occupation and the definition of specialty occupation and who qualifies and who doesn't, and whether if a job requires a bachelor's with more than one major, is it not a specialty occupation? And does does it have to say in the OH that all employers require a bachelor's degree in a specific field, or is it enough to show that a majority of the employers require a bachelor's? So there's so many things that need to be changed. And what's happening right now is that the jobs are just going out of the country, and that doesn't help anyone. They're just being moved to India, which helps India, and to other countries, but it really doesn't help the economy of the United States. So I definitely hope that there is some change with reference to the H1B numbers in the very least.
Okay. Thank you so much, Prashanti. Prashant?
All right. So first of all, thanks to the Higher IT team for hosting all of us. Dan, Ranjit, Rajni, Zayed in the background, working his magic on all the technical aspects of this, muting, unmuting us. I know how difficult that can be. But, I would say kind of a parting message from this webinar, especially for students that are in F1. I can't tell you the number of clients that have come to me in the last couple of months who have maybe worked for an organization that, they paid them $200 for an offer letter, just so they could stop their unemployment clock on OPT or their STEM OPT. And, individuals that, very desperately feel like that they need to do the wrong thing in order to continue to stay in the US. And I've seen those clients now get stuck during a visa stamping appointment or interview back in India. So they're in an even bigger mess that they're unable to get out of, right? So just staying on the right side of the immigration rules and regulations is going to be so important, just because if you look further down the line, 10, 15 years, it can really have an impact on your immigration history and future immigration benefits. So I would say just staying on the right side of those rules and regs is always important.
Thank you so much, Prashant. Looks like Ranjit wants to say something. Ranjit?
And I'm good. Thanks, for all your time. I know it's a busy season, and taking time and educating the viewers and employers. It means a lot to everyone. I really appreciate taking time. You, Prashanti, Prashant, and John. Really appreciate it. Thank you.
Yeah, John. Any last message from you and golden words from your side?
So I think we can expect to see, especially with the fee increases, USCIS will continue to divert money from adjudication to FD&S activity. So that's going to impact processing times. It's also going to impact how much hassle people are exposed to. Then when the new H1B modernization regulation comes out, it's going to become incredibly difficult to do the H1B process, especially without an attorney. And so that's another issue that people are just going to have to deal with. It's going to be a mess for a while until certain legal issues get hammered out with that modernization rule.
Okay. Thank you so much, John. And, since we have a lot of questions left, I'm sure that people are wanting to directly connect with you. So for that, I would like to give out, your details. So let's start with Prashanti. So everyone, if you need immigration help, you can, to reach out to Prashanti Reddy, you can give her a call at 212-354-1010 or mail her at prashanti@reddyesq.com. You could visit her website, reddyesq.com. If you want to reach out to Jonathan Waston, you can give him a call at 703-216-8148. And his email ID is john@waston.law. His website is waston.law. If you want to reach out to Prashant, you can reach out to him via email. His mail ID is info@dubaylawoffice.com. And if you want to reach out to Yvette Bansal, her contact number is +1 630 303-6165. Her email ID is yb@udetivisa.com. Her website is udetivisa.com. And if you want to reach out to me, and if you're looking for a project placement, you can email me at rajni@higheritpeople.com. My contact number is +1 732 707 9151. You could visit our website, which is higheritpeople.com. And now, viewers, thank you so much for tuning in such large numbers. And that's a wrap for today's discussion. I want to extend heartfelt thank you to our incredible guests, Prashanthi Reddy, Prashant Dubey, Jonathan Wasden, and Yvette Bansal for sharing their insights with us. And of course, a big shout out to our amazing co-host, Ranjit, for adding that extra flair to our conversation. And lastly, I want to express my gratitude to our viewers for tuning in and being a part of this engaging dialogue. Remember, immigration is not just about laws and policies, it's about people and their aspirations for a better life. Until next time, keep your dreams alive and your paperwork in order. This is Rajni Parara signing off. Take care, and don't forget to subscribe to Immigration and Jobs Talk Show.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.